Adult film star Stormy Daniels says that she spoke with New York prosecutors in the hush money probe against Donald Trump and has agreed to make herself available as a witness or for further inquiry if needed. Former Trump fixer Michael Cohen ended his grand jury testimony yesterday. He later spoke to MSNBC's Nicole Wallace about the grand jurors and how much longer this could last.
Do you believe you were the last witness they heard from?
You know, I don't know the answer. Again, I'm not involved in the inner discussions regarding the completion of this case or the length of time it will take before which Alvin Bragg's office makes its ultimate determination. But I would suspect that I am certainly close to the end of the testimony that is necessary.
And joining us now, former U.S. Attorney and senior FBI official Chuck Rosenberg, now an MSNBC contributor. So, Chuck, what can we read from the fact that Cohen has finished his testimony? Prosecutors reached out to Stormy Daniels to go over her story or find out whether she would be available or whatever. Or how close might they be? What would they want to talk to Stormy Daniels about? And what can you read from all of this?
Well, sure. Let's start with Mr. Cohen, Andrea. I think he's probably right. He's an important witness, and traditionally you talk to the important witnesses toward the end of the investigation. Now, we also know that prosecutors have met with him almost 24 times, and that's really not all that surprising either. But if he's now testified in the grand jury and they have everything they need from him or think they need from him, then he's likely right. They're probably close to the end. But that doesn't mean that Mr. Trump will be charged. It just means they're near the end of the investigation, and now they have to make a prosecutive decision. I expect they know precisely what it is they want to do, but it seems like they're probably still discussing it within the office. As for Ms. Daniels, also an important witness, someone the prosecutors would absolutely want to talk to. She was not on the paper, so to speak. In other words, she wasn't the one who falsified records or, claimed that checks were for Mr. Cohen's retainer services as a lawyer when, in fact, they were hush money payments to her. But she was the reason behind the hush money payments. And so obviously someone prosecutors would also want to talk to.
Would they want to make sure of what her story would be if she were to call it by either side in a future case, if there were, a case? Do they need to sort of nail that down and not have any surprises?
No surprises, Andrea. That's exactly right. And that's, by the way, how and why you use a grand jury. You take a person's testimony under oath. And so if they were to change their story subsequently, they were to say something other than what they said in the grand jury under oath, that grand jury testimony is substantive evidence of what the truth is. So if you saw that the light was red, Andrea, and you testified in the grand jury that the light was red, and at the actual trial, you got nervous or you were intimidated or you honestly forgot, and instead of saying the light was red, you said it was green, prosecutors could use your original grand jury testimony to prove the color of the light. That's why we use grand juries, as you said, to nail down cases, as we say, to lock in testimony.
Of course, she wasn't in front of the grand jury. She wasn't under oath. She was on a Zoom call with them. But is there any way to read what next steps would be? Let's say they do make a decision that they did want to prosecute. They would still have to have a closing argument or a presentation to the jurors. They would have to have a vote. What would the actual timeline be at that point?
Yeah, the presentation is the right word, Andrea. Prosecutors would go to the grand jury with a proposed indictment. They might have a summary witness to help the grand jury recollect all of the facts that it has heard over however many months it's been sitting. And then the prosecutors would walk out, leaving the indictment behind them with the grand jurors, and the grand jurors would deliberate and vote in secret. That's how you present an indictment to a grand jury for its consideration. And if the grand jury agrees that there's probable cause to believe that Mr. Trump or someone else broke New York state law, they would return what we call a true bill, an indictment. And in that point, Andrea, the case moves forward in criminal court.
I briefly want to ask you about Fulton County, Fani Willis's probe. on potential election interference. NBC News now confirming that the special grand jury, which is not an indicting grand jury, has disbanded. They did hear a phone call from then President Trump telling then Georgia House Speaker David Ralston that he wanted a special legislative session to overturn the results. This is another instance. We didn't know about this call before. Does this have, any major evidentiary impact?
Yeah, it has what we would call probative value. It helps to demonstrate Mr. Trump's state of mind, his intent. And as you and I have discussed many times, Andrea, intent is key in all these cases, proving someone acted intentionally.